Okay, I guess we could begin. Good evening, everyone, and thanks for joining us tonight. So this is going to be our tutorial on the week 3 topic on certainty and completeness. Before we proceed to the discussion of tonight's tutorial problem, I will be prepared to take some questions from the class. But I'd like to highlight first what we intend to do for tonight. So after completing this topic, you should be able to identify whether, so I'm going to look at the chats in a short while, but let me just focus first on the objectives for this tutorial. After completing this topic, you should be able to identify whether a contract is sufficiently certain or whether aspects of a contract are uncertain, and identify whether a contract is sufficiently complete to be enforceable by the court, distinguish between an agreement to agree and an agreement to negotiate, and be aware of the legal consequences of this distinction, discuss how to deal with an incomplete contract and any agreed mechanism to resolve the incomplete elements, distinguish between the acceptable discretion and an illusory promise, and identify the types of contracts that may be affected by requirements for particular formalities. But again, before we start talking about the tutorial problem and take some questions about the quizzes or other assessments, I forgot to say hello. We had a week-long university break last week, which I hope was quite helpful for you. It was quite nice that, you know, after 3 weeks of just having the term, we then had a short 1-week break, because that gives a lot of us the opportunity to just catch up with work and perhaps other family commitments. So that was good. Okay. I got from Tiffany that she wanted to ask a question on the quiz, and there might be other questions that some of you may want to raise in relation to the assessments. Tiffany, would you like to use the mic, or should I respond in relation to the chat that you've written in the chat box? You're free to use the mic, obviously, because the problem with the chat box is that those who might be viewing this recording will be unable to see what's going on in the chat box. Or they could access the chats, but it won't directly correspond with, you know, what we're discussing. They may have a problem trying to draw the connection between what's on the screen and what's in the chat box. Tiffany, would you like to use the mic? Tiffany, so should I read the things you've written in the chat box instead of using the mic? Okay, so Tiffany might have a problem with her mic. So I'm just going to read her question for the benefit of those who will be viewing this tutorial. So hold on. Okay, there. So this is a question from Tiffany. I was trying to find some information on this week's quiz, but I noticed that under the assessment tab on the side of Moodle, the link to quiz 2 is open and gives information. However, the link to week 4 short quiz doesn't open. Okay, this will be open the day before. So as soon as I'm ready with the quizzes, I will make that link available. However, the quiz itself will only be available on Friday this week, set out in the schedule as stated in our Moodle page. Now, will the questions be focused on topics 1, 2, 3? The questions will be focused only on the topics of weeks 1 to 3. So hold on. This time we're talking of week 3. Yep, it's only going to be limited to weeks 1 to 3. So in other words, up to today's discussion. So the topic for next week, which is on intention to create legal relations, there won't be any questions on that particular topic. So the coverage for this week's quiz, which comprises 10% of the final grade, will cover the materials only from weeks 1 to 3. And it also means that when we have our next quiz, the second and final quiz, hold on, the 2 quizzes comprise 10%. So this week's quiz will comprise 5% of the final grade. And then the second short quiz will also comprise the other 5%. So that the total grade for both will be 10%. So in relation to this week's quiz, I've yet to determine whether there will be 5 quiz questions or there will only be 10. It's likely that there will only be 5 quiz questions. Likely, but I'll make a decision on that on Friday itself, at the time that I release the quiz. So as I said, the quiz for this week will correspond only to the weeks 1 to 3 topics, and there won't be any questions in relation to weeks 4 and onwards. How long do we have to complete the quiz? I'd have to get back to you on that, Lisa, because I can't really remember. I think that if I'm not mistaken, at the moment you start answering the quiz, you're only given a certain amount of time to answer the questions, and you're not permitted to go back to take the quiz again. So this is a one-time quiz you need to undertake, and there is a specific time frame for that. So we have a period during which you can decide to answer the quiz, but once you've actually opened and logged into Moodle and tried to start answering the quiz, you're given a set time to do that. I can't really remember how long it would take. That's something I'll have to check. Other questions from the class on anything else relating to the assessment or any other topics that we had previously discussed? Do we have to take it on the Friday? That's a good question. I have a sense you don't have to take it on a Friday. It will be opened on a Friday. And then, if I'm not mistaken, you're given 24 hours within which to answer it. Hold on, let me just check. Okay, so it says here that you are in fact given 60 minutes within which to complete it. So there's only one attempt that you can make. Now, in relation to that specific question of, during the period, how long you could actually decide to take the quiz, I would imagine that the quiz will be open all the way until Saturday, even until the evening. So the quiz will be open until the evening of Saturday of this week. But as I said, once you've commenced the quiz, you will only have 60 minutes within which to complete the assessment. And you're only given one attempt for the quiz. Okay. Of course, I'd like to give you a reminder that you have an assessment which is actually due this week, and that relates to the semester plan, which is due on Thursday, 10th of December. You're given until 15 minutes to 12 midnight of the 10th, or Thursday. Any questions before we proceed? None? Okay, so we could begin. Okay, can I ask someone to volunteer to read the tutorial problem for us? Volunteer. Peter, Luke, Amelia, Peter, would you care to read the tutorial problem for us? Okay, we've got Latisha volunteering. Latisha, yes, please.
Maria had decided that she had had enough of the city life. She ran an online business. The many regional communities now had great broadband. So she decided to make a sea change and head to a coastal community in central Queensland. The only problem is she hadn't worked. Sorry, one second. She hadn't worked out which one yet. She decided the best way to proceed was to move out of her rental property in Brisbane and spend a month or 6 weeks backpacking northwards along the Queensland coast until she found the perfect place for her. Before leaving, Maria engaged a small local company of removalists to empty her house, place her belongings in storage, and then deliver them to her new location. Once she decided to give the job to this particular company, she sat down with them to draft up a brief contract. The contract set out the date for the removalist to collect her belongings and identified the location and circumstances for the storage. The contract nominated a specific price for the collection and a price per week for the storage with 3 months to be paid in advance. As Maria had not yet decided where she was going to live, it was not possible to nominate the address for delivery. As a result, the moverless said it was not possible for them to give her a final price. If she decided to live in Caloundra, just north of Brisbane, the price would obviously be much cheaper than if she decided to live in Ayr, just south of Townsville. The parties simply agreed that when Maria had determined the delivery address, she would let the removalists know and they would determine the appropriate price. Finally, Maria was concerned about the safety of her goods in transit and in storage. She wanted the removalists to insure her goods, and she offered an extra $500 overall for them to do so. The removalists agreed, and the words "with the goods to be insured" were added to the contract. If having had her backpacking adventure, Maria would eventually decide on a location and a dispute emerged about the contract. Are any elements of this contract void or for uncertainty or completeness? If so, would the contract be able to save the contract?
Thank you, Letitia. So let's give it a few seconds or even a minute for you to figure out how to answer the question. Some of you obviously have come up with an answer in Moodle, but we'll give it about a minute for you to just get your mind around the tutorial problem again.
Don't worry about it.
Okay, I guess we could begin. So can I get everyone to post his or her answer in the chat box? Are any of the elements of this contract void for uncertainty or completeness? Let's begin with that question there. Are there any elements of this contract which would be void for uncertainty or incompleteness? Okay, I mean, I just saw a comment from Tiffany. Don't all contracts have a degree of incompleteness? Would anyone else wish to add anything? I'm not exactly sure if everyone has been given the chance to provide an answer in the chat box, so we could start discussing this. Should I just give a few more seconds to everyone to give a response? So as a reminder, for you to be able, I was just thinking, oh, it's a different assessment altogether piece. Okay, yeah. We could probably start answering this. Okay. Can somebody tell us, in relation to the contract, is this an executory contract or is this an executed contract, and will that really matter? So let me focus. So instead of asking a legal question, let me ask a factual question. From your understanding of the case facts or the problem, have the removalists already started to undertake part of their bargain? In other words, if you will examine the nature of the contract, there are three aspects to the bargain in relation to the removalists. One would be to empty her house, and then to place her belongings in storage, and thirdly, to deliver the items to a new location. So that's in the second paragraph there. So it says, before leaving, Maria engaged a small local company of removalists to empty her house, place her belongings in storage, and then deliver them to her new location. So from a factual viewpoint, what is your understanding of the case problem? Have the removalists already started to fulfill part of their bargain? Because that leads to my next question, whether or not what we have is an executory contract or one which is an executed contract, and whether or not our characterization of the nature of the contract, whether it's executory or executed, will make a difference in terms of whether or not we will determine that the contract is void either for uncertainty or incompleteness. So let's focus first on the factual question. What is your understanding here? Have the removalists complied or fulfilled any part of the bargain? So yes, if they've fulfilled part of the bargain, and no, if they have not. So if it's yes, it means that they fulfilled parts of the bargain, whether it's emptying her house, placing her belongings in storage, or delivering them to a new location. So can I see a yes or a no here? So from my factual viewpoint, factual only, from your understanding of the case problem, have the removalists fulfilled a part or parts of their bargain? Can I get some answers here? I haven't seen anything in the chat box. Oh, hold on. The answers are probably there. I just needed to scroll down. Sorry. Okay. The answers were there. I didn't realize that a lot of the chats had popped up. So yes. Okay. So we're kind of all in an agreement that parts of the bargain have in fact been fulfilled by the removalist. So just for us to pin down the nature of this contract, are we therefore dealing with an executory contract, or are we dealing with an executed contract? And then I will ask, the question of what really is the reason for the distinction. Is the distinction important? So the question for me now, which I'd like you to respond to, is what kind of contract are we dealing with? Is it an executory contract, or is it an executed contract? And if you could, please provide an answer as to what you understand the contract to be. If you say it's executory, explain why it is. If it's executed, explain why it is so as well. So characterize for us the kind of contract that we have, and then indicate your explanation of what constitutes an executory as opposed to an executed contract. Okay, so we've got an answer from Liu. We've got an answer from Liza. So from Liza, executed because it is partially completed. From Liu, the contract has been executed because the removalists have fulfilled part of the contract. Can I get the answers of the others? So from Peter, executed, partial, executory to be completed. So from Chrissy as well, executed because they have started providing their services as contracted to do so. Okay, so I guess that's sufficient for now. Okay, so from Amelia, executed. Okay, good. So we seem to have the sense that the contract has been executed. And from Dominique, the contract is executed because the contract has been partially completed, at least in relation to the removalists. Why is it important for us to make a distinction between a contract that has been executed and a contract that is still executory? Why is that distinction important, or is the distinction crucial? Can somebody take the floor? Is it important for us to distinguish whether or not between a contract that is executed and one that is executory? Is it important? Is that distinction important? If so, why is it important? Can somebody take the floor? Okay, so from Liza, because the courts will try and find a way to save that executed contract. Yep. Okay. So I'm looking now at the legal effect. Okay. So so from Tiffany here as well, if they are different as executed and is done and finished, executory means that all of the terms are complete. Okay. I'm going to respond to that shortly, just to make a clarification of the point raised there by Tiffany. Okay. So from Liza, why would you say that the courts will try to find a way to save an executed contract? Why is that? Liza? So my question was, why would a court try to find a way to save an executed contract? Wash it with soap. And so it's not too big. From Liza, no mic. Okay. Okay, so good. So we've got an answer there from Liza. She says, because it is partially completed and the court does not want one person to have an advantage over another. Okay, can somebody take the floor and just expound on what Liza here is saying? Why is it important to make a distinction between an executory contract and an executed contract, and try to relate that question to the facts in the case problem that we have? Come on, can I get somebody to take the floor? You can use the mic.
Manjo, I'll give it a go because no one is really talking today. I'd probably just say with regards to because obviously a contract is between two parties, in this case the removalists and Maria, and if the removalists obviously have started taking out their side of the contract, it would be really unfair, I guess, for the court just to throw out a contract, and they'll probably do their best to be equitable, I suppose, and give some sort of compensation that seems just to the point of how far the contract has been executed and how much work has been performed by one party, I suppose. That's probably what I'd say for now.
Yep, thank you, Chrissy. That's the correct answer. It's actually quite complete. So as Chrissy pointed out, if we're dealing with an executed contract, what it means is that one of the party at least has started to fulfill his bargain or has started to fulfill his or her obligations under the contract. In this case, what the removalists are likely to have done would be to have emptied her house, the house of Liza and Maria rather, and then placed her belongings in storage. The point being that if this contract were to be considered purely something being void on the basis of the fact that a term was uncertain or the contract was likely incomplete, we have an unfair situation where Maria would have benefited from the fact that her goods had already been her house had already been emptied and her belongings had already been placed in storage. That would be a very unfair situation. So in relation to the legal principles, if the court characterizes a contract or an agreement as having been executed, at least partly, by one of the parties, in all likelihood, the courts will try to find a way to save the contract to ensure that both parties fulfill their respective parts of the agreement. On the other hand, if it is merely an executory contract, in other words, none of the parties has started to fulfill his or her parts of the bargain or his or her obligations under the contract, then the courts are unlikely to try to save the agreement. Okay, so that's quite clear now. Now, the other thing here is, if you look at the case facts, and we do this, and I'm making this clarification for the purpose of, I'm not sure how relevant it is to the legal memorandum, but it could be in the nature of a final online assessment. It is possible that when you look at the case facts are a bit incomplete, in the sense that the case facts don't really tell you whether or not the removalists have actually emptied their house. The removalists have already emptied the house of Maria, and whether or not they've actually started to put her belongings in storage. It is natural for us to assume that those two parts had in fact already been fulfilled by the removalists, but on the other hand, it can be argued that the removalists actually haven't started to empty her house. So depending on the way that you interpret the facts, you may end up with a different answer. And in that case, your answer will be, in either case, will be correct, for as long as you clearly articulate what your basic factual assumptions are. So on the one hand, as I said, it is natural to assume that the contract has been executed because of the fact that Maria had already started her backpacking adventure, and there seemed to have been an agreement that at the time she was out of her house, that was when the removalists would empty her house. On the other hand, it could be argued that the removalists actually have not started to empty the house, and certainly not have started to place the belongings of Maria in storage, in which case, what we're dealing with would be an executory contract. So again, it is crucial that when you provide your answer, you must be clear about what your factual assumption is if the facts are a bit ambiguous. So if you characterize this contract as being executed because you feel that the removalists have already emptied the house of Maria and placed her belongings in storage, then you can argue, there being an executed contract, then you can make the argument that the courts will likely try to save the contract. On the other hand, if you make the final if you make a factual assumption that on the basis of the facts don't seem to be too clear on whether or not the removalists have started to fulfill part of their bargain, then you can make the assumption logically that this is an executory contract. And because it is, the courts are unlikely to save the contract on the ground that it is uncertain or incomplete. Okay, now moving on. Let's clarify first. Is there a distinction between the notions of certainty and completeness? Or are they actually one and the same? Is there a distinction between the principle of certainty as opposed to the principle of completeness? Okay, so going back to the question, you could take the floor or put your answers in the chat box. Is there a distinction between the notions of certainty and completeness? Or Are they one and the same?
Hey, Manjo,
Yes.
I'd say that there is a distinction between the two, because even though a contract can be complete, there still can be a bit of ambiguity in it, which will make it seem uncertain. But as long as both parties know exactly what they're both trying to achieve and fulfill, then that can complete the contract.
Okay, good. So we know that there's a difference. So when we say that the contract is complete, when do we know that a contract is actually complete? So Lisa here says completeness, an important term is missing. What exactly do we mean when we speak of a complete contract? What are the key elements of a contract in that sense? So for Martin, completeness covers all the terms that ought to be there, where certainty is involved with a meaning of a specific term or terms. Okay, so when do we know that all the terms of a contract are there? What exactly are the essential elements of a contract?
I guess I'd probably say that the promises between the two parties, so what each one's promising and what consideration is being given, and then obviously the terms and conditions for carrying out or fulfilling those promises.
Okay, can you just, who was that? Was it Chrissy? Chrissy, can you just repeat that for me? What were they again?
Okay, sorry. I'm not too sure if it was loud enough. Basically, a contract is comprised of two generally, so promises between parties and the consideration for the promises as well, and then all of the terms and conditions that go with the carrying out or fulfilling of the promises.
Okay. Okay, comments on, thank you, Chrissy. Would anyone care to provide a comment to what Chrissy has suggested to be the key terms of a contract, or the essential elements of a contract? So, okay, I'm not going to put numbers this time. Some are speaking of ad idem. There's intention to create legal relations for Martin. Yep. There's negotiation. I'm not saying yet this is something that I think we already covered, but we're just kind of reviewing them. So what exactly are the essential elements of a contract? Does anyone remember? So if this were a quiz and I ask, what are the four, which of these elements here are actually elements that should be part of a contract for it to be complete, and which are not? What would be the answer? And are we missing something here? Okay, so for Martin, what we have would be an agreement. Okay, I'm just going to copy that. Okay, where do I put this? Hold on, I'm just trying to figure out, look for a space. Okay, just as a review, the four elements of a contract would, okay, then from Lisa. Okay, so in general, if we speak of an agreement, then we know that we're dealing with an offer and an acceptance. So they could be looked at as one or two elements. So an offer and an acceptance constitutes an agreement, or that will demonstrate ad idem, or a meeting of the minds. If you have an agreement, it necessarily means that there is an offer, and that offer has been accepted. That's why you have an agreement. If it's just an offer, you don't have an agreement yet. And the agreement, therefore, means that you have an ad idem, or a meeting of the minds. Completeness is not necessarily an essential aspect of the contract because, as we said, even if the contract seems to be incomplete, if the contract is actually executed, it is possible for the court to find a way to try to save the contract. So it is not an essential element of the contract. And as stated by some, it's always likely that contracts are incomplete, in the sense that in relation, for example, to what the offer was and whether or not the offer was accepted, there may not be clarity in relation, for example, to if it were a painting job, what kind of color was going to be used, what kind of brand was going to be used for painting. So in that case, you have an offer, and it can also be accepted, but there are some aspects of it which might appear to be incomplete. The other one is obviously the intention to create legal relations, or the intention to create legal consequences, or the intention to be bound. So they're all the same: intention to create legal relations, or legal consequences, or to be bound. So that's the second or third one. And then obviously you have consideration, which we will be discussing later on, which usually is the price that one of the parties is willing to pay for the obligation of the other. And then we have the requirement of certainty. The requirement of capacity. So we've got 1, 2, 3, and 4. And then, okay, we have a statement from Martin. Are we talking of essential elements to formation? Substitute completeness for certainty then. Okay. Okay. Yep. Okay, so we can proceed now. Where are we? So I'm going to erase this part now. So can somebody clarify for us again, what exactly is the distinction between a contract that is uncertain and a contract that is incomplete? What was the distinction there? So what does uncertainty relate to, and what does incompleteness relate to? Okay, so we've got an answer from Martin. I'm just going to put it on the screen because, as I said, those who will be viewing the recording will have a hard time looking at it in the chat box. Thank you, Martin, and thank you as well, Chrissy. So for Martin, incomplete, it means that some essential term is lacking. The terms which we mentioned are above, or some essential element is missing. And then, so from Chrissy, it means that not all terms have been completed. That means that it is incomplete. Now, what exactly does uncertainty relate to? So again, from Martin, just gonna... Okay, so for Martin, uncertainty means that when you look at the terms of the contract, the essential terms of the contract, they might be quite ambiguous. So in which case, it can be difficult to ascertain what it is that the parties are meant to be fulfilling. So there is an uncertainty in the term. So when you look at, it could mean that it is not specified enough. So again, in relation to the issue of completeness, we're looking at whether or not all the essential elements or terms of the contract are present. Because if one of the essential terms is missing, then you likely do not have a contract. So in other words, if you don't have an agreement in the sense that you don't have an acceptance of an offer, then in that case, you have a contract that is incomplete and therefore void, because an essential term of the contract is missing. Or if you have a situation where one of the parties does not have an intention to be bound or does not have an intention to create a legal relation with the other party, again, what you have is an incomplete contract, which means therefore that the contract is void. But if you talk about the notion of certainty or uncertainty in on the other hand, it means that the essential terms of the contract are there, meaning the four that we've identified. But as far as trying to determine what it actually means, what, for example, the offer actually means, or what the bargain really relates to, there is some element of uncertainty in it, or some element of ambiguity. So it is difficult, therefore, to determine what the parties may have actually agreed upon. Okay. So the next question that we ask is, if the contract, for example, let me just highlight the question there. Okay. If the contract is uncertain, and let's assume that we're dealing with an executed contract, what happens then? So we make a distinction at this point between a contract, an executed contract that is uncertain, as opposed to an executed contract that is incomplete. So let's just look first at the notion of an executed contract that is uncertain. So if you have an executed contract that is uncertain, how will the court most likely approach the legal problem? Do we make the assumption that the court will try to save the contract? And if it does, what exactly will the court do? How will the court resolve the problem of ambiguity or uncertainty?
I think the court would try and solve the problem by actually trying to remove that term from the contract and seeing if the contract would actually still fully function without that term.
That's one, yes. What else? Thank you, Liu. So there's a question of severity here. The point being that the court might sever parts of the contract. So that part of the contract, if the entire contract can be considered to be valid even by just removing that uncertain term, then that's going to be okay. But on the other hand, if by removing that uncertain term, what you end up with will be a contract that, for example, ends up being incomplete, then the court will be unable to save it. On the other hand, if that term that is incomplete can be removed without affecting the validity of the contract because it will remain complete, then the court will be able to do that. So that's one way by which the courts can address the issue of uncertainty. How else can the court remove or deal with the issue of uncertainty? Okay, so we've got an answer here from Chrissy, and then I'll go back to the answer of Martin. The court tries to use other information in the contract to make sense of the uncertainty. Okay. So the court will try to use other information in the contract to make sense of the uncertainty. Now, put it this way, that answer, for example, of Chrissy, and this is correct, the answer of Chrissy is correct. So here, Chrissy is suggesting that in relation to uncertainty, what the court will try to do is to use other information in the contract. This seems to be different from the usual approach in contracts interpretation or construction rather, where the court will apply the so-called reasonable man's objective standards of in terms of trying to interpret or construct meaning out of an uncertain term. So here the proposal is the court will try to examine the entirety of the contract, and in doing so make sense of the uncertainty. So the construction of the court therefore relies upon what the parties have agreed as demonstrated or shown in the contract, as opposed to coming up with an objective standard of what a reasonable person is likely to do, or is likely to interpret an uncertain term. Okay, so the other approach would be the court tries to make sense of other information of the contract. Is there another approach? So from Martin, okay, so we've got the answer from Martin now. The third approach will be so the court will try to give it meaning by reference to reasonableness or external standard. So there are two parts. There are two ways by which the courts can deal with an executed contract, or one of the terms is uncertain. Either number one, the court will try to examine what the parties seem to have agreed upon, looking at the terms of the contract itself. So that's that's looking at the contract on the basis of what the parties have actually attempted to agree upon. But the other aspect of it is to apply an external standard to determine what appears to be reasonable in terms of constructing or interpreting a term that seems to be uncertain. So that will be comparing it with an external standard. So we've got three ways at least by which courts will try to address the issue of uncertainty. So one is because the courts will try to say the contract, because it is an executed contract, the courts may remove that part of the contract which is uncertain, assuming that the contract will remain complete. In other words, the four key elements of the contract that we've initially identified and which are there on the screen, for as long as the contract will remain complete, if the court removes that part of the contract which is uncertain, then the court will do that in order to save the contract. Two, the court may also try to resolve the question of uncertainty or ambiguity by looking at the contract itself, what is within the contract, what is written in the contract, to make sense of how to define what the uncertain term really relates to. And a third way by which courts will deal with uncertainty will actually be to apply an external standard, and then to ask the question of a reasonable person. How would a reasonable person most likely try to make an uncertain term sufficiently certain? So that will be the question there. And in relation to external standards, for example, if it is conceivable that the parties may have attempted to agree that it will be the price of, as usually found in an industry, that will be the basis on which to shed light or provide more meaning or specificity to an ambiguous term, the courts will also do that. So in this case, for example, what is the ambiguity here? Where is the uncertainty here? The uncertainty relates to the price of delivering the belongings to a new location. So that's the uncertainty there. And can we address the uncertainty? We certainly could, because there will be scope or a range of prices for a delivery from the house of Maria to her new location. You looking at the industry, for example, it is possible for you to conclude or to determine what a reasonable price would be for that delivery from the house of Maria to the new location. Okay, so we've addressed the issue of uncertainty here. Now, the other question there was that are there elements of the contract which are actually incomplete? So we know that parts of the contract are uncertain. Are there elements of the contract which are incomplete? So from Luke, the delivery location, delivery price, insurance cover. Okay, anything else? Now, what I'm going to do, I'm just going to remove part of the, hold on, no. I'd rather put it in a separate, hold on, screen. Now, how do I do this? Let's go to a different file, hold on. Okay, I'll probably just put it here anyway. Oh, no,
If you just go up to the top left and it says new slide and it's got a little plus button on it.
File, new, presentation, new from template.
If you just jump out of that one and just underneath home, it's got new slide. And just underneath home there.
Okay, hold on. It doesn't seem to be working for me. Okay. Okay, I'm just gonna erase for now some of the facts which are not really important, but I'm gonna restore them later on. I'm gonna restore them in the file. So we've got some answers here as to some of the aspects which are incomplete, and I'm just gonna pick up the answers as indicated in the chat box. You've got the price from Martin, delivery location from Luke, insurance cover. So we've got the delivery price. Yeah. Huh? Okay. So those three, I guess. Okay, hold on. Okay, are we missing anything else? So the contract seems to be incomplete because the delivery price isn't there. We don't have the delivery location. We don't have the insurance cover as well, it appears. We don't really know what the insurance cover entails, or don't we? I've already erased that part. So anyway. The question is, so the question that we can ask here at this point, these three, the delivery price, the delivery location, and the insurance cover, are they essential terms of the contract? And therefore, these are the question of, would it have made a difference if the contract were executory? Assuming that the contract was executory, not an executed contract, and then the delivery price was not stated, the delivery location was not stated, the insurance cover, for example, was not stated in the contract. Would that mean that the contract is void if any of these were incomplete, assuming that what we are dealing with is an executory contract and not an executed one? So let's do it one by one. Okay. So assuming we have an executory contract and the delivery price is not stated, would it mean that the contract will most likely be considered void? Is that yes or no? Can I get people to say yes or no in the chat box? And we'll try to wrap this up in 5 minutes because we've got a class at about 7:15. Okay, I'm scrolling down now. Okay. Okay, so the answer should be that if this were an executory contract, meaning none of the parties have started to fulfill their part of the bargain, the contract will most likely be considered void. If what you have is an executory contract, same thing with the delivery location, because in the, okay, how about the delivery location then? What do you think? How about the delivery location? assuming that the delivery location is incomplete, meaning it hasn't been stated, would that mean that the contract is likely to be declared invalid by the court, assuming you are dealing with an executory contract? So we've got an answer from Martin, only as it affects price. Okay. In this sense, the delivery location would actually be crucial, wouldn't it? There is a huge difference between delivering it to a location which is about 50 kilometers from where Maria lives, as opposed to delivering it where the location is maybe 1,000 or even 5,000 kilometers away. In other words, chances are, if you're dealing with a removalist, assuming that they agreed on a price, because they did not in this case, assuming had they agreed on a price, the removalist would have agreed to a specific price only if the removalist knew what the final location would be. Because otherwise, he would be at a loss. He might end up losing money or losing in the bargain if he were forced to deliver the goods at a much farther place. So to that extent, therefore, if the delivery location had not been indicated in the contract, the contract is unlikely to be saved by the court. Because in that case, it will be difficult to consider what exactly did the removalist, for example, agree to, or what exactly was the offer that was accepted by the removalist. The removalist could not have accepted it without knowing what the location was, and that was exactly the reason why they had not yet entered into a final agreement in relation to the delivery price and the delivery location, because they did not know where Maria exactly will end up living later on. Now, finally, let's speak of the insurance cover. What if you have an executory contract rather? So in other words, again, none of the parties has actually tried to fulfill his or her part of the bargain. So what if you have an executory contract and the agreement of the insurance cover had not been indicated in the agreement? Would that affect the validity of the contract? So we're now just speaking solely of the insurance cover. If it were an executed contract and the contract failed to state anything about the insurance cover, would the contract become void? No. No from Sophie. No from Liza. No from Luke. Okay, I agree that the insurance contract will most likely be valid. The question is why? How different is that term about the insurance cover? Why would this contract be valid even if the insurance cover had not been stated in the agreement? Whereas if the delivery price or the delivery location had not been indicated, the courts will likely find this contract to be invalid. Why is that? So from Liza, yes, the insurance cover is not crucial to the execution of the contract. So again, so the reason is, as far as the insurance cover, it is not really an integral part of the contract, as Chrissy would also state here. As far as the essential terms of the contract, the parties can continue to fulfill their parts of the bargain. The two crucial parts of the bargain would be the offer of Chrissy is that she would pay the removalist if they did 1, 2, 3, meaning they remove the items, store the items, and then deliver the items. Those are the three crucial parts of the offer of Chrissy, of Maria rather. She would pay. Now, for as long as the contract can be interpreted in such a way that both parties are actually aware of the respective bargains, then you don't have a problem. You have a complete contract. The insurance cover, in other words, is not an essential term because the contract is still complete, even in the absence of an insurance cover. Okay. It's 7:05. we will end the tutorial at this point. If you have any questions, feel free to send me an email or post it in the Moodle site. But before we go, would there be any questions? None? Okay, so thank you everyone, and I'll see you again next week. Don't forget that we've got the semester plan due on Thursday this week. Thank you everyone, and good night. Bye.